started. So as I said, talking back to basics, we're talking sexual harassment at work. So I'm presenting, my name is Rebecca Richardson, and I'm an associate in the employment law team. And Ellen will also be assisting today. She is a lawyer in the team. All right, let's get started. So we're going to talk about what is sexual harassment, how to handle sexual harassment in the workplace. We're going to look at some case studies, and we'll have some Q&A time. But as I said, happy to answer Q&As throughout. Okay. So what is sexual harassment? So it is unwelcome conduct of a sexual nature that a reasonable person would anticipate would offend, intimidate, or humiliate. In terms of what that could mean, sometimes it is something that you may not personally think would offend, intimidate, or humiliate, but the court might say that a reasonable person would. So it's important as well for us to be aware of, that we ourselves are not always the reasonable person in this scenario. So as for what is unwelcome conduct, this is subjective, so based on how the individual perceives and experiences the conduct in question. So as I said, something that you may not think is unwelcome or wouldn't be unwelcome to you, may be unwelcome to someone else. What is a sexual nature? That pretty much goes without saying. It's anything that you would expect. You err on the side of caution, so it includes things like gestures, comments, contact, and finally, offensive, humiliating, or intimidating. So this is an objective test. So whether a reasonable person in the same situation would have anticipated that offense, humiliation, or intimidation might result. So this is the pinnacle case, Richardson and Oracle. I'd be surprised if you haven't already heard us bang on about this case. But in this particular case, I believe the applicant's full name was actually Rebecca Richardson. So I'm very aware of this case. Rebecca, in this particular case, she was younger and she worked at Oracle, and there was an older colleague of hers, and he made a lot of unwelcome comments. So we should go away for a dirty weekend. I'll bet your sex with your boyfriend was hot. Let's go sneak into a corner. You want me. We have this hot love hate thing going on. So these are actually pretty, these are pretty overt. This isn't the case where somebody is, making comments that are borderline or could be misconstrued. You can see here that these are pretty explicit. In this particular case, I think it went on for, this harassment went on for a few months. And as a result of the harassment, Richardson developed an adjustment disorder. Now, as HR, are we all fairly familiar with adjustment disorders? Has this come up? Now, I'm looking at the sea of black and I'm just imagining all of you nodding. But as you know, it's a pretty, it is the mental health kind of pandemic, as it were, of the workplace. Adjustment disorder is a temporary disorder that is a result of something stressful. So, for example, this. Now, she was originally, when she first went to court, Richardson, she won, but she won a small amount of damages. Off the top of my head, I think it was like 40 or 50.
I think it was about 10 or 12. 10? She got at first instance. Yeah.
It was, at first instance, it was a small amount. And then she appealed, and at second instance, she got awarded $100,000. Now, that was it's the case that we always refer to because it's the case where damages for sexual harassment jumped up significantly, because as Gab mentioned, about $10,000 beforehand was actually, that was standard. That was what everyone was getting. And after Richardson and Oracle, it's not quite true to say that the floodgates have opened, but it is true to say that judges are much more willing to award higher quantums in line with Richardson and Oracle. And in fact, we will talk about a case later in the presentation in which somebody, I think it was 2019, 2020, was awarded $120,000 in general damages plus an additional $50,000 in aggravated damages. So we will get...
Sorry, I might just jump in there and just perhaps explain or get you to explain, Beck, when you talk about general damages for the benefit of people dialing in, what do you mean? Like, what's it really
absolutely. Mean? So there is a slide for that.
I jump in. I'm sorry. Good, because it's worth discussing. There is a slide for that,
but look, we will get to it, and forgive me if I don't get to it, and I'll get back to it. But I will talk a little bit about what economic damages are, non-economic damages, and when we hit that particular case, I'm also going to talk about aggravated damages.
Excellent.
All right. Yes. Okay. So this is also important for HR. So despite the scary slides I've just shown beforehand, it is important as well that we allow everyone to have a personal life. So there is such thing as a respectful relationship in the workplace. So conduct which is not sexual harassment includes sexual interaction, flirtation, attraction, or friendship, which is welcome, invited, mutual, consensual, reciprocated. This is very complicated in this day and age. I mean, we're talking about things that we didn't talk about maybe, say, 5 years ago, which includes things like power dynamics. However, at the same time, in this office, we're still of the firm belief that there can be such a thing as a respectful relationship in the workplace. I think we debate it all the time where the line is, and that's where we get, interesting cases, and that's where we get difficult decisions from HR. For example, is a Valentine's Day, what about Valentine's Day flowers? One-off Valentine's Day flowers. What do we think? Sexual harassment or not? And the reality is it's entirely context specific. And presumably if the two employees in question already have a good rapport and might already be interested in each other romantically, it's certainly not sexual harassment. But if we've got two employees, one of whom is uninterested and perhaps has never spoken to the other one, where does it land? And as I said, it's always different. Now, in that particular scenario, I would say if you had somebody receive Valentine's Day flowers and it's out of the blue and it's a one-off scenario, that would be certainly open for them to say, sorry, I'm not interested. And perhaps if it needs to, it could escalate to HR, and HR could just reinforce the disinterest of the recipient of the flowers. I don't think that the Valentine's Day flower scenario is a scenario in which anyone would be terminating employment.
Do you think that argument of it being a one-off event is really interesting? I'm glad you touched on that because it's so complicated. I'm sure that everyone in here has had some experience that they've dealt with, whether or not that's assistant staff or not, through HR. It's interesting.
So absolutely, I agree. A one-off event could absolutely be sexual harassment. It depends on the event. In that particular scenario, I think because
of course,
if it was just flowers and it perhaps wasn't accompanied by, let's say, an inappropriate poem,
yes,
I would err on saying that is pretty clear to me to be, I guess, an expression of interest, which,
of course,
if nipped in the bud at that point, doesn't need to go down any sort of legal pathway. But I think if it was a part of a pattern, so in which somebody had, sent flowers every week and the person says, stop sending me flowers, then we're in an entirely different scenario.
Yeah, absolutely.
So we'll talk a little bit about out-of-hours conducts. So employees are also entitled to a private life. Out-of-hours conduct that may be of legitimate concern to employers includes conduct that is a continuation of behaviour in the workplace or affects the workplace, or where the employer has exercised some control over either the person's off-duty behaviour or the premises where the conduct occurred. So let's use the flower example. If they start sending flowers in the office and then they move to sending flowers at the home, and that is unwelcome conduct from the beginning, and the person says it's unwelcome, they might say to the employer, hey, it's unwelcome, and then the flowers continue arriving at the home. They might say, to the employer, this is happening. The employer might legitimately at that point perhaps say to the employee, please stop sending the flowers. I would say that's probably a lawful and reasonable direction. It's a continuation of the behaviour from the workplace. That's the sort of thing. Again, we're talking about something that's fairly innocuous, but if you imagine that that's paired with other forms of sexual harassment in the office. Okay, so what are the consequences of sexual harassment? For the victim, obviously, pretty dire consequences. I think we're all pretty aware of those now. There's been a lot of work done in the media, and a lot of work from victims talking about their experiences of sexual harassment. But specifically for employment, creates unhappiness in the workplace, a drop in productivity, absenteeism, and high staff turnover. And these are all things in HR which we are trying to avoid. So sexual harassment is a work health and safety issue for employers. There are due diligence obligations for directors and officers. It can be a workers' compensation issue, and perpetrators and employers can be ordered by the courts to compensate victims. Employers can be held vicariously liable for sexual harassment and discrimination where they have failed to take all reasonable steps to prevent misconduct, and in some cases there can be significant damages ordered. Now, go back to your point. I'm talking now about economic loss and non-economic loss. So if you go to court, you've got a discrimination claim, the court is going to ask, what's your loss? The point of the court is to try and compensate you or reimburse you, compensate and reimburse. Now, to reimbursement, so that's your economic loss. Say you have been sexually harassed, and as a result of the sexual harassment, you might take a period of leave. You might take, for example, 6 months unpaid leave. Now, that's a financial loss, and if the court agrees that it was a result of the sexual harassment, they may order that the employer pays the 6 months salary that is lost. So that's one thing. The second thing could be future economic loss. So if someone is sexually harassed and they have a terrible injury, so more than just an adjustment disorder, say they develop chronic depression, perhaps, and it results in them being unable to ever again work full time, or unable to ever again work in their particular field, whatever the case might be, the court will ask, and well, what is this going to mean for your future? So there are some complicated calculations at play, but essentially they're going to look at what is your economic loss like in the future. So if you are completely incapacitated for work, and the medical evidence indicates that that could be forever, and you are, say, 40, you as the employer could be up for an enormous amount of future economic loss there, because the person might say, well, I was planning to retire when I was 65. Please give me 25 years salary. Now, it's unlikely that the court's going to give somebody 25 years salary. There's a number of calculations that the court does, but still it could be not insignificant. And there is some case law where employees who've brought these sort of claims have received very large portions for their economic loss. So whilst I was talking before about Richardson Oracle, that was about her non-economic loss. That was the compensation. The $100,000 was the compensation for her non-economic loss. Whereas there are lots of cases where people have received, I've seen, 400,000, 600,000. Not perhaps lots might be overkill, but there are cases where people who have significant ongoing injuries. It may result in them having high future economic loss, and the court might compensate them for that. Now, to the non-economic loss, this is the money that the court awards the individual for their hurt, humiliation, distress. Now, that is separate from the injury. It's a complicated concept, but in essence, you can imagine that it is humiliating and it's distressing to be harassed in the workplace. So, for example, the sorts of things that a applicant might take to a court and say, these are examples of my non-economic loss. So loss of enjoyment of life. You might be stigmatized in your particular field or in your workplace. You might have, failure to sleep, you might have a breakdown of your relationship, your personal relationship, all of these sort of things that are not specifically, for example, I have adjustment disorder, or I have depression. It's slightly different. It's more about what effect did this have on your life. So those are the two heads of loss. And as I said, there is such a thing as aggravated damages. It's much more rare. We'll talk about it briefly when we get to the case where there are some aggravated damages.
So just to be clear then, in Richardson and Oracle, what happened there was that Miss Richardson, she was sexually harassed. She actually left, right? She left the employment of Oracle. She went on to a job and she actually got higher pay. So she moved from as a consequence of the sexual harassment, ended up moving to a job of higher pay. So she didn't actually have any economic loss as such. What she did have, though, was the adjustment disorder and the hurt and humiliation distress, and the $100,000 that we were talking about before was the new bar, as it were, of what the court is, the appetite of the court, what they're willing to award for this hurt, humiliation type distress. So the bar went from about $10,000 or $12,000 up to $100,000 for the general damages component. So the reason this is important is because look, the economic loss component, it is what it is, but the salutary message for HR is that even if there is no economic loss at all, the mere fact of sexual harassment in the workplace can well cost you or your organisation, up to easily $100,000 in just general damages. So it's actually quite a significant case, has had significant consequences for the practice of discrimination law in this country. And I can honestly say, in this practice, we refer to that case probably 5 times a day when we're down in conciliations and mediations, writing our letters of demand and whatnot. We'll start, the bargaining starts. We start around 150 now, thanks very much, regardless of plus economic loss. So it might be, that's why you read judgments of, millions, because of the economic loss component.
Richardson and Oracle is 2014. I mean, times have moved on.
Exactly.
And we will look at a case in just a moment where someone received 120,000. Also, in Richardson Oracle, the nature of the sexual harassment, obviously it was bad, but it's not necessarily the worst sort of sexual harassment that could exist.
It's really important, isn't it, for our HR Breakfast Club members to be aware of that. So in Richardson Oracle, I think it was about 13 incidents over a 6-month period. It was the kind of, grisly comments that you put up on the slide, sort of seedy sort of verbal comments. I think there were a couple of minor levels of touching. And when I say minor, I don't mean to be disrespectful, but as you say, Beck, on the scheme of things, we do see more severe type sexual harassment in the workplace, right? So, there's right up to a spectrum of serious sexual assault or rape, right at that end. So in Richardson Oracle, Mr. Tucker, the perpetrator of the sexual harassment, he was on the sort of, low to medium end sexual harassment. That sounded in $100,000 in general damages. So had that been more serious sexual harassment, or had she suffered some serious economic loss, which is usually what happens, it's rare to go from one job to a higher paying job. Quite often these people are derailed for years over it. And so that's why that decision is so important, because what it tells HR managers is this is a real issue, leaving aside the moral side of it and all that, just from a mitigation point of view. As HR, you need to be on top of this stuff because it can cost your organisation, at least since 2014, a serious amount of money, not to mention all the other headache and HR time that gets chewed up, and the resignations and all the palaver that we all know is associated with these things.
Not an easy job.
No, it is not.
All right. For who can be liable, so is both the employer and the perpetrator. So the victim might sue, the victim will almost always sue the employer and will sometimes join the perpetrator themselves. Now, in terms of vicarious liability, there are some things that employers can do to reduce the likelihood that they'll be found liable. And those things include taking all reasonable steps, as the courts say, which include having a good sexual harassment policy and having good training. And then those are just the background things. Obviously, there are other things. So for example, if somebody comes to you and says, hey, I keep getting flowers sent to me, and you go, great, I love flowers, enjoy. That's not all reasonable steps, is it? So there are the background things, and then there's the response directly, I would say, to the individual scenario.
So that's why it's so critical for, I think your point, Beck, is why it's so critical for HR to do stuff about sexual harassment, because ultimately the employer becomes vicariously liable for it. It's a high bar, all reasonable steps, what all reasonable steps are, but I think you're going to talk about it later, are you, Beck? I better not jump in as to what you need to do. But from an HR point of view, it's sort of not really optional. You should be doing these things as HR at least to try and ensure your organisation's discharging its vicarious responsibility for sexual harassment.
So now Ellen's going to help us speak a bit about some of the developments in the area. So Ellen, take it away.
Great. And it's, it's a good segue there that you were talking about, in-house ways to address it. So what I'll be speaking about now is one of the recommendations that was implemented as a result of the Respect at Work report. And that is the introduction of stop sexual harassment orders, which have extended the scope of the current stop bullying jurisdiction in the Fair Work Commission. So this came about, I think, in September of last year, which the application process operates more or less in the same way as the stop bullying jurisdiction would, which we would be familiar with, and we may revisit with a back to basics session later on in the year. But there is an important difference now if you're making an application for a stop sexual harassment order, and that is that there is no need to demonstrate that the behaviour is repeated. So as Beck was talking about before, this is really nuanced, but it sends an important and a strong message in scenarios where it is absolutely inappropriate. So under a stop bullying application previously, you could pursue sexual harassment if it had occurred more than once, because it then satisfies the bullying requirements of the bullying jurisdiction. So the stop sexual harassment avenue provides victims with an avenue where they have been subject to sexual harassment on one occasion. And let's just say someone has been, very much harassed at work, obviously, and they've gone to HR and said, this isn't okay, and there's nothing happening. The victim can then apply for an order with the Fair Work Commission. And again, this is usually after they have exhausted all of the in-house options that are available. Now, there are a lot of requirements to satisfy here. And I guess kind of setting aside the typical ones we would look at with stop bullying, one of the important similarities is that to apply, you must still be connected with the workplace where the conduct has occurred. And there has actually been a decision that's come out of the stop sexual harassment jurisdiction where, unfortunately, we didn't really see a lot happening because there was no connection with the workplace where the conduct had occurred. So I guess
just quickly, Ellen, so what you're saying is the person who applied for the stop sexual harassment order stopped working there in between having applied and and getting to the hearing. So because of the nature of this particular jurisdiction, the commission only cares about whether or not it can stop sexual harassment occurring. You leave, you've stopped it.
Yeah, that's exactly right. That's because the purpose is to stop, and I guess I'll talk about that a little bit later in the outcomes that can come out here. So on that, which is really interesting, is that the harassment must have occurred when the worker was at work, as we were talking about earlier, but at work has not actually been defined in the legislation. But generally, if you look back at what Beck was saying earlier, this encompasses work events, working away from the usual place of the premises or even via forms of electronic communication. However, there is no equivalent requirement for the perpetrator to have been at work. So the harasser does not actually need to be a worker. They might be a client or a customer. Now, if the victim holds a reasonable belief that they have been sexually harassed at work, they can then apply using the F73 form, which is the same application that you would use to apply for an order to stop bullying. It's now been extended, so you can apply for an order to stop bullying, to stop sexual harassment, or to stop both. So where the behaviour occurs as a crossover, the applicant can deal with both in the same application, which I think is really important for you all as HR managers to understand, that you might be responding to both. Now, the Fair Work can issue any order that it wishes or sees necessary in order to stop the sexual harassment. And that might include relocation or even dismissal of the harasser. It might be introduction of workplace sexual harassment policy or other appropriate training where there is a lack or a distinct absence of such policies within the workplace. They might recommend changes to rosters or changes to reporting lines. So really the Fair Work Commission can order anything, except they cannot order payment of compensation or any other amount of money, in the way that, I know I keep banging on about this, but it's about stopping the behaviour and offering protection in that way. So the damages are not relevant in this situation. Now,
can I just jump in, Ellen, just because there's a question there. Somebody's asked about whether, just that point about, do you have to exhaust all internal avenues before you go to put your stop sexual harassment application in? Do you know that?
Yeah, that's
I'll look it up.
A really good question. From my reading, and again,
Yeah.
it'll be good to check.
It's early days, right? Yeah.
Exactly, but I believe that it's relatively subjective. So say that the HR manager has been sending you flowers every single day. It's not really reasonable for you to then go to the HR manager's office and ask them to pursue something against yourself. However, if it is reasonable for you to maybe just speak to someone, it looks at, I guess, the circumstances. That's my understanding at this point.
Yeah.
And we're still, we've only seen that one decision that came out, and unfortunately it hasn't given us a lot of commentary on how it's operating.
Yeah, right. For my knowledge, in terms of the stop bullying jurisdiction, because this stop sexual harassment jurisdiction is very similar, right? That there were provisions to say it was really in the discretion of the Fair Work Commission as to whether you had to exhaust other options or not.
Yes.
In my practical experience in the stop bullying jurisdiction, it depends on the merits of your case. The Fair Work Commission can be a bit reluctant and sort of, well, are you sure you haven't exhausted, is there other options, Ms. Sullivan? They'll often ask that, but I've always demanded they exercise the jurisdiction that's court's given them. In other words, if we've decided to be there, then we need to determine it. I would have thought sexual harassment's, there shouldn't be reluctance from the bench to deal with these things if they possibly can. I'll have a look in the Act while you're talking, Ellen, and see if there's something more specific there, but I don't think so. I think the answer to the question is exactly as you say, Ellen, that it's kind of discretionary in the usual sense. I doubt it would be that you absolutely had to exhaust everything, because, as you say, there's going to be all sorts of reasons why that can't happen or doesn't happen effectively, and I would have thought the Fair Work Commission would be keen to be jumping in if an application's dealt with it. But as you say, early days, because this is all part of the Respect at Work changes, right, that came in September. So we're still learning.
That's exactly
that question. All right. Sorry, I'll get back to you, Ellen.
No, thank you, Gab. I think that's really important. As we know, the flexibility is important, because no situation is the same, and where the purpose is to make the workplace safer, it's important to be able to look at how we might be able to do that. And I think that handing back over to Beck, who will talk about your duties and responsibilities as a HR manager and what we can do to stop these situations getting.
Before we hand back over to me, I'm going to throw it right back to you and ask about the fine for contravention of order. Do you know off the top of your head who pays that? So who are these orders? Is the order to the individual, the harasser? Is the order to the workplace? If the order is to the individual and they contravene it, do they pay the fine, or does the workplace pay the fine? And I'm asking this not because I know the answer. I don't.
Yeah, absolutely. So as you can see on the slide, so say we've gone through the process and the commission has made an order. So say they order that the employer dismisses the harasser, and they then contravene that order. I would believe then it would go down to who has actually contravened the fine. So in the order, so in that situation, it's relatively clear. Say it's an employer that hasn't fulfilled their obligations, but that's a really interesting question. Say that the order was to stop sending flowers. I would assume that we would look then to the individual who has continued to send the flowers, but if the workplace has not done everything that they reasonably can to stop it, I would imagine then we're looking back to the workplace. I should have a look at that in the background. That's a really good question. Yeah, Gab, do you know?
Yeah, I'm just looking at the legislation as we speak, and I will go back to that. Sorry, there's two questions there. One is whether you have to exhaust all internal avenues before you can go to stop bullying. Answer is no. I'm just looking at section 789 F. It's the same test as for bullying. So Heidi, the answer to your question is you don't have to exhaust all internal mechanisms. That said, the Fair Work Commission is statutorily obliged to consider all relevant matters, including other actions and investigations on foot. So in my practical experience, what happens is, if there's an investigation on foot or something, and then the workers run off quickly and said, I'm tired of waiting, I want to get an order, the commission will take that into account. So as with all these things, just in terms of the legal process, once you file an application, you don't get to court next day, as we all know. There's a process. There's usually a mediation or some sort of conciliation for it, and there'll be discussions about what's really going on, and those kind of other mechanisms that are around will be discussed, and ultimately they are obliged to take them into account. So that's the first question. The second question was, well, hang on, who's the order actually made against, right? The stop bullying order actually made against. It's the same. It looks to me like, and again, it's early days, so lawyers are often paid to be creative, but at the moment, it's if the commission is satisfied that the worker has been sexually harassed at work and there's a risk it will continue, then they can make any order it considers appropriate to prevent the worker from being sexually harassed. So just think about that, how that might look. And I would have thought it would well have extended to order, if it's so the employer isn't the applicant or the respondent to the application, but nonetheless orders could be made that would say, well, the employer has to allow the employees to come into work at different times, or separate their working spaces, or whatever, and direct that there be no flowers delivered to the said office, for example, because of course so look, it could well, employers could easily be picked up from that. I'm looking at section 789 F of the Fair Work Act. I'm just going to ask what section I'm looking at. So the prospect at work changes, which were legislated for at the end of last year, what they effectively did was amend the Fair Work Act in a number of regards. What Ellen's talking about now is the changes to the Fair Work Act. If you go and look in the stop bullying jurisdiction that we're kind of becoming reasonably familiar with, they added extra and harassment orders. That was part of the suite of changes. The others, there were also changes either proposed or on foot as for the discrimination legislation, but for the minute we're talking about the Fair Work Act.
So changes. Holly's asked another question, yeah. Yes. Yes is the answer. When they make an application, you'll be alerted by the Fair Work Commission. You'll have an opportunity to respond there'll be a conciliation. If the parties can't work it out at conciliation, then there'll be a hearing. You will be very aware by the time any order is made.
Absolutely. And that's a good question, Holly, because, you know, speaking to you in your capacity as HR people, not your capacity as you know, potential victims or perpetrators, but as HR, yeah, your job is to deal with this stuff, right? It's got to the point where somebody's dashed off to the Fair Work Commission and your organisation's on the wrong end of one of these. Like, surely the brief is to deal with it pronto, right? So, but you know, I'm imagining, it's early days here, but I'm imagining, honestly, as a lawyer, I see this forum as not terribly useful. You know, because we had the same with the bullying jurisdictions. It's actually quite technical. There's all these sort of criteria that mean you might get lots of people making applications, but there's not ultimately very few orders are actually made because of the technicalities. The point about quitting or the termination point is a really relevant one. So because it's a preventative jurisdiction, it's to stop the sexual harassment. So if either the victim or the perpetrator has quit, which is usually what happens, then there's no jurisdiction. So you're wasting your time being there, right? And the employer's response, if notified for an order, would be, not at risk of future sexual harassment because they've left, right? Although that's interesting too, if the perpetrator's still hanging around. They've done it once, why mightn't they do it again? I don't know. Yeah. Look, it's early days in this, but I would have thought that the real issue here, I would have thought, is there's no money in this.
Yeah.
And I don't mean to be disrespectful to anybody, but just being realistic about the cost and effort involved in any sort of dispute or legal matter. Money is usually something that people need to think about, if not just at least to cover their cost of having
pay a lawyer to go to a hearing.
Correct. And it's expressed. If you look at that section 789 FF in the Fair Work Act, it's very clear that the Commission cannot order payment of money, right? So you cannot get a stop sexual harassment order and somehow end up with a swag of money. All you're going to get is an order that looks a little bit like, you know, like domestic violence orders and stuff. They say, you know, keep away, stop sexual harassment, must not send flowers, must not send bad poetry, must not proposition, whatever. You're not going to get NPS pay $1 million, right? Or pay $500. If you want that, you've got to do the heavy hitting discrimination matters. So if I was an HR manager and I got one of these stop bullying orders, I should have already known about it. I should have already known. Presumably it's been festering for months. And this is one of the feral ones that really you probably need a lawyer on. But if you weren't aware, then you need to get in and deal with it quickly. But in the scheme of things, honestly, this is bad publicity and probably a headache, but nothing on a federal court discrimination application or something that you might get lobbed on you from as a lawyer. I take that step if I was acting for an applicant. So sort of worry, but then don't worry that much. So there's a question there that says, is there an anti-stopping?
Is there anything stopping an employee from getting an order and then getting a lawyer for the money? So going here, getting the order, being successful, and then subsequently suing in a different forum. No, but
time.
Oh man,
time.
That's a slow way to do it.
Yeah, that is a slow way. Correct. Just stop messing around, go straight for discrimination, and you'll get a conciliation conference within a couple of months.
But I will say, if you got an order from the Commission agreeing that sexual harassment has occurred, you would be thinking, hey, this might not be so difficult for me to take to a court.
But you might be out of time. Don't forget, there's time limits to commencing discrimination. So look, it's a really good question, right? So the answer to your question is no. Trust me, from an HR point of view, by the time you're even asking these questions, you are in a world of pain, and you really probably should be getting some advice about how to shut these things down in toto. You know, again, as an HR manager, your job is to you want your workplace to be productive and harmonious. This is neither of those things, so you want that dealt with pretty quickly. And when I say shut it down, I mean do what it takes for that to happen properly, and get a deed of release, shutting down all courses of action, right? In exchange for us doing this, we will all agree to withdraw everything forever and release everybody from everything and start fresh. That's where you want to go. But I better be quiet because we've got some interesting case studies.
We do have some interesting case studies. Let's see. All right, what do you need to do? We'll race through this somewhat because it's something that you're all aware of. You know, modeling respectful behaviours from the top down, responding to complaints promptly, reasonably, and in accordance with your policies. Having policies that include definitions and reporting procedures, and increasing staff awareness of the policy, conducting training in the policy. So these are all like HR 101. I won't lecture you about this, but look, it's important that you are, in terms of taking all reasonable steps, it is important that your policies are up to scratch. So more of the same. Again, I think this is, let me know if anyone wants to dig into it further, but I think this is all HR 101. Oh, yes. Oh, okay, Renee, in relation to responding to complaints.
Here we go.
What if the complainant goes on sick leave?
Oh, come on, that never happens, Renee. I don't know what you're talking about.
Like every single time. Okay. Can the employer make contact? So if that's the complainant going, or as opposed to the person, all right, yes, in all cases, sort of, yes. There are some nuances here, but in essence, an employee being on sick leave doesn't mean that you can't contact them, especially in circumstances where people go on long periods of leave. I mean, we've got to be smart about this. If someone's in hospital, for example, you might want to use your best judgment about whether or not it's appropriate to contact them. But if someone's on sort of a miscellaneous leave for a couple of weeks, they haven't told you why, it's absolutely open to you to make contact with them. You don't ask them to do large amounts of work, but you are, for whatever the reason, contacting them. Now, Renee, in this circumstance, is this a scenario where someone throws in a grenade, says, I've been sexually harassed, and then they're on leave and that's it? Oh, okay. Yes. All right. So you need more information, for example. Well, I mean, this is somewhat complicated. It sounds like there's probably, to this particular scenario, some details. I mean, it's important for the employer, if you're truly concerned that you have someone who's perpetrating sexual harassment in the workplace, it might be important for you to get more details. If they've said to you, someone's sexually harassing me, and they're not giving you anything further, then
I'd send a short note saying, look, we take this complaint, we're sorry to hear it, we take this complaint seriously, we're happy to investigate if you give us more details when you're ready. Because really it puts you people in an impossible position, doesn't it? You can't investigate these sort of generalized, I've been harassed by this guy out. That's outrageous. So, sorry, it's not outrageous. It's very difficult for HR to manage that. So until you've got some proper particulars or a reason to really sniff around them, I think that's all you can do.
Yeah, and the other thing you can do is you could always, for example, if they do have a doctor, you could say to them, look, we've got some questions, you might find them distressing because you're on sick leave. We propose to send them to your GP for you to go through them with your GP by your side if you're really concerned about the health of the individual. All right. Oh, yes. Okay. Thanks, Renee. All right. Let's move on. Okay. So this is an old case, and it's only included in the slide just to show you that sexual harassment never changes. It's the same as always. This is an old case in which we all agree there was sexual harassment. So a 15-year-old receptionist was being harassed by a 74-year-old colleague at work. He made unwelcome comments and contact with her, and he tried to kiss her. That is textbook, it is standard, and the court found that the complainant was sexually harassed. That is stock standard. Now, look at case study 2. This is more recent. It's 2019, and then there was an appeal in 2020, which found the same thing. But all the way here, we're looking at the same stuff, right? So it never changes. For this particular matter, so Hill and Hughes, it's the matter I flagged a couple of times as being the one where the complainant got 120,000 in general damages. So you remember we talked about how Richardson and Oracle in 2014 was 100,000. Well, 2019, we're at 120,000. This was in some ways, this was probably, again, it's awful to do this, but on the scale of sexual harassment, it was probably a little bit worse for a couple of reasons. So this poor applicant, she was a mature age student, I think, who trying to get into the legal profession for a variety of reasons. She moved up to the, what's that area called? Northern Rivers, I think. She had to move to the Northern Rivers to be close to her ex-husband for childcare purposes. Anyway, there aren't that many good law jobs, apparently, according to her, in the Northern Rivers. And she got this offer from a firm, and they say, you know, we're going to train you up. It's going to be great. And I think it's probably a sole practitioner, actually. He says, you know, I'm going to train you up. It's going to be great. And then he just, it's terrible. He viewed himself as a Mr. Darcy type. He was in a relentless attempt to woo her. He was, for example, writing her messages in poor French. He was, you know, doing all of the things, tried to take her horse riding, all this kind of strange stuff. But the problem was, in this particular scenario, I mean, it was relentless. She was a single mother. She didn't have many other options. And he coerced her. Well, he tricked her into coming to a work trip. He says, hey, I've got this really amazing legal thing that's happening in Sydney. It's going to be so interesting. Let's travel to Sydney together. And that, you know, they get to Sydney. He goes, let's stay at my brother's. They get there, and, you know, then he starts appearing in her room in his underwear, or like lying on her bed when she comes out of the shower. Like, this is what I mean about escalation of the sexual harassment that we saw in Richardson and Oracle. This guy took it to a new level. She was pretty clear with him, no, but she kept staying because she needed her job. Single mother, difficult position. And then when she kept making complaints and saying no, he kind of threatened her, like, oh, you know, you don't want to make complaints against me, sort of thing. And it's that sort of threat, partially, which led to him, the court awarding aggravated damages against him, which was, so you remember I said it was $120,000 in general damages. So the hurt, humiliation, distress caused by his actions, and then $50,000, partially because of that. And the other part was actually because he was a lawyer, and the things that he'd done as a lawyer were unconscionable. So one of the things he did was he offered to act for her in her family law matters. And so he gathered a lot of information about her private life, which he had to because of family law. And then he used that information sort of against her to try and woo her. And so the $50,000 there, it's sort of specifically partially because he's a lawyer and the things that he did. But in any case, that's sort of one of the more recent matters where someone got about 120,000. If there was contact, then you'd be imagining probably a larger amount of general damages. You know, if it says things here like, you know, he was in her room in his underwear, but what if, you know, he had then like physically restrained her and kissed her at the same time? We'd be probably looking at more. And I mean, I say that as someone, you know, with lots of clients, and I have heard of worse examples of sexual harassment than this. And those are all matters that never saw the light of a courtroom. But it's not something that you think this never happens. It can happen. And we just haven't necessarily seen all of those cases make it to hearing. And again, as you all know, not a lot of matters make it to hearing. People settle beforehand. It's very expensive for the complainant. Now, speaking of it being expensive for the complainant, we'll just quickly touch to some upcoming potential changes to the law. Before I get there, again, this is standard on the slide. Be respectful, model respectful behaviour, have good policies in place, just be a good HR manager. All your kind of classic stuff is there on the slide. Just quickly move to some of the changes that we need to watch out for in this space. So Gab, you were mentioning that there are a couple of things that might be on the cards for the ACT.
There are, Rebecca. Sorry, I've just jumped into a different screen. Look, there's a couple of things coming up, but we're kind of out of time to explore them. I think probably just look, as HR managers, I think the takeout is be aware, this is kind of expensive. And if I could just add one thing back to your case studies, the obvious sort of profile of risk is, older male perpetrator, junior female victim. That's the standard sort of picture we have in our head when we think of sexual harassment, and it's endemic, right? Me too, we know that. But just something that I think I've said this before, but I'm sure you're aware of it, but the other risk profile are actually colleagues who were in a consensual relationship and have fallen out. And they're no longer, so that which was previously invited and mutual and welcome is now unwelcome, and we still work together, and it's now HR's problem. So just to point out that there's no reason why that scenario cannot also fall within the sexual harassment rubric. You would expect the damages ranges to be different, but there is a lead, Clayton Utz and Izzo, Styles and Izzo is the case that sort of picks up that profile as well. So just be aware of that as HR managers. And of course, the job, as Beck's saying, is really to be on the front foot here, which is important, because one of the changes that's on foot, you've probably heard about this positive duty to prevent either sexual harassment in the case of federal arena, or in ACT, there's moves afoot, or there's the government's consulting currently on whether we shouldn't have a positive duty to prevent all forms of discrimination, not just sexual harassment, but also age discrimination, disability discrimination, etc. So we won't get ourselves too worried about that, because they are mere law proposals. They're not law yet, but I think that the takeout is, if you in HR are advising your organisation to be on the front foot with sexual harassment, so model all those steps that Beck had in the slide, model it all, making sure you've got your policies, making sure you've got your training and everybody knows about it, then A, you'll be able to defend any sort of, all reasonable steps type vicarious liability. B, you'll have a happy and productive workplace. C, there's a fair chance you will discharge any positive duty that might become law in the next 12 months or so. So you put your organisation in the best place to defend it. And, you might just make somebody else, a victim's life a lot better, because it's no fun for them. But we're out of time, so I best be quiet. And I think
we're out of time.
Beck,
and
you're going to wrap it up.
Trying to remind us the next HR Breakfast Club will be held on Friday, the 18th of March. And we'll send out some communications details about what we'll be talking about then, and we hope to see everyone there.